Mark Reckless.
The Home Affairs Committee commenced our report on a cross-party basis 10 months ago. That report shows too close relations, clearly, between the police and the media, and in particular, News International. Indeed, there were so many lunches and dinners, it's surprising that senior police officers had time for anything else. But despite that, I don't incline to the view of high-level corruption or conspiracy at the top of the police. In my view, as far as the police is concerned, and Lord Leveson may of course find otherwise, but my view on the evidence I've seen is it was more sort of cock-up, perhaps incompetence in some places. And the reason I take that view is because the evidence our committee saw on the role of the CPS and the very clear way in which the CPS let down the police. Now, I asked John Yates yesterday, did he think blame had been fairly ascribed between the police and the CPS? And he said no, he most certainly did not. And he felt that he had been bumping his head against a proverbial brick wall in trying to get people to see the role of the CPS. And it may be more interesting for the media to look at the role between the media and the police, but it's the role between the police and the CPS, I believe, that gets us to the heart of this. Now, the question is, why weren't those 11,000 pages of Montclair documents, why weren't they looked at? Why didn't the police do anything? But also, why didn't the CPS do them? And even yesterday, Keir Starmer wasn't quite clear as to whether the CPS had seen all of those. He said they'd only seen the ones up to August. But we now hear from the member for Torridge and West Devon that on the 8th of August, both the DPP and the Attorney General were notified of what he said, a vast array of offending behaviour and the material to back it up. Yet, what happened? They don't seem to have done anything about it. And the current DPP looked at this in July 2009. He was new to the job. He went through all the materials. He tried to find out what happened at the time. And he concluded that nothing happened because the law. To prove the criminal offence of interception, the prosecution must prove that the actual message was intercepted prior to it being accessed by the intended recipient. And it was on that basis that the CPS constrained the police investigation. Now, whether the noble Lords Goldsmith and MacDonald were asleep on the bridge, whether they just gave incompetent legal advice, or whether in some way they prevented this police investigation, are very serious questions. And I'm delighted to see that the Prime Minister has revised the terms of reference of this Lord Leveson inquiry, and then it's going to look at the role of the prosecuting authorities and why the CPS gave, in my view, this absolutely extraordinary and clearly wrong advice that you had to prove the message was listened to before the interception. Because if you look at Section 2.7 of the Regulation of Investigatory Powers Act, it is clear on this. Parliament made our intentions clear. And we said that communication remained in transmission while a system is, and I quote here, storing it in a manner that enables the intended recipient to collect it or otherwise have access to it. So all this stuff from the CPS that the police had to prove the message was intercepted before listened to, there is no basis for that. But it seems that's what stopped the investigation back in 2006. And the noble Lords MacDonald and Goldsmith had to answer for themselves on that. Why did they give that advice, which is clearly wrong in the light of Section 2.7? Now the CPS and Keir Starmer, I think, is loyally doing this, and as far as I can see, acted properly and tried to look into this in July 2009. He's now recanted from the evidence that I just quoted that he gave to the DCMS committee, and he's saying at best, oh, well, perhaps it's uncertain, perhaps the police could prosecute, perhaps it could be prosecuted. But even that hugely constrained the police because it made it much more difficult for them. And I believe actually the advice of the CPS was much clearer at the time. They said you couldn't prosecute on that. And that is the problem that we're left with. And I want to know why the CPS did that. And I believe the CPS needs to be more accountable. And I look forward to seeing stage 2 of these elected commissioners, not just for the police, but the CPS, as with the Royal Commission 81, they should be put under elected control and oversight.